Hello, this is Ron Climer at First Real Estate School in Hendersonville. We're back for section 6 of the comments from the North Carolina Real Estate Commission. If you're following me in the comments, which are a free download from the North Carolina Real Estate Commission, which, by the way, that's www.ncrec.gov. It's a free download. It may be published in your textbook. It is in mine. But if you don't have a copy of it, get a copy of it. And I'm basically just reading it to you. This is section 6. This is Ron Climer from Hendersonville. And I'm on page 15. Actually, I'm leaving page 15 because the very first heading on page 15 is broker in charge. Requirements to have a broker in charge. Paragraph B of Rule A110 states that the general rule that each real estate firm is required to have a broker designated by the Commission who meets the qualification requirements to serve as broker in charge of the firm's principal office, and a different broker to serve in the same capacity at each branch office. It's important to note, as discussed previously under license requirements, that the broker in charge is not a... Hold on a second. That the broker in charge... It is important to note, as discussed previously under license requirements, that broker in charge is not a separate license, but only a separate license status category. No broker may be a broker in charge of more than one office at a time, and no office of a firm shall have more than one designated broker in charge. Rule A110 describes the lone exception to the rare circumstances when two or more firms share the same office space. Notice that paragraph A defines the term office, principal office, and branch office. These definitions are not repeated here. Exceptions to BIC requirements for certain firms. Paragraph D of Rule A110 provides a licensed real estate firm is not required to have a BIC if it has been organized for the sole purpose of receiving compensation for brokerage service furnished by its qualifying broker through another firm or broker. 2. Is treated for tax purposes as a subchapter S corporation by the U.S. Internal Revenue Service. 3. Has no principal or branch office. And 4. Has no licensed or unlicensed persons associated with it other than the qualifying broker. Sole proprietors. In addition to each firm having to have a broker in charge for each office, most brokerage sole proprietors, including sole practitioners, must also be a broker in charge. Rule A110 provides that a broker who is a sole proprietor shall designate himself or herself as a broker in charge if the broker 1. Engages in any transaction where the broker is required to deposit and maintain monies belonging to others in a trust account. 2. Engages in advertising or promoting his or her services as a broker in any manner, or has one or more other brokers affiliated with him or her in the real estate business. Note, however, that maintenance of a trust account by a broker solely for holding residential tenant security deposits received by the broker on properties owned by the broker in compliance with GS 4250 shall not, standing alone, subject the broker to the requirements to be designated as a broker in charge. The most misunderstood of the 3 broker in charge triggering requirements for sole proprietors cited above is number 2, engage in advertising, promoting his or her services as a broker in any manner. Acts as a sole proprietor that triggers the BIC requirements under number 2 include, but are not limited to, placing an advertisement for his services as a broker in any form or any medium, distributing business cards, indicating that he or she is a real estate broker, orally soliciting the real estate business of others, or listing a property for sale, which inherently involves holding himself out as a broker and advertising. Therefore, a broker sole proprietor may lawfully provide only limited brokerage services without designating himself as a BIC. A couple of examples of permissible broker activities by a broker sole proprietor who is not a designated BIC include receiving referral fees from another broker or brokerage firm for referring business to the broker or firm representing a relative or a friend as a buyer's broker in a sales transaction, provided the broker has not solicited this business but not advertised or promoted himself for his service, and does not hold earnest money beyond the time it's required to be deposited in the trust account. The practical effect of these requirements is that a broker who will be operating independently in most cases must also designate himself or herself as BIC. The real significance of these requirements for a sole proprietor will be better understood when the qualification requirements to serve as BRC are subsequently discussed. Requesting designation as BIC. Paragraph F of Rule A110 states that the broker who is to serve as broker in charge of an office is responsible for requesting his designation by the Commission using the form required by the Commission. Requirements to serve as BIC. The qualifying requirements to serve as a broker in charge pursuant to paragraph G of Rule A110 are: broker license must be on active status, but not on provisional status. A provisional broker is ineligible to serve as a broker in charge, as a broker whose license is inactive or expired. Broker must have at least 2 years full-time or part-time equivalent real estate brokerage experience within the preceding 5 years or qualifications the Commission finds equivalent to such experience. The requirement is for actual brokerage experience, not just having a license on active status. Note that by submission of a broker in charge designation request to the Commission, a broker certifies that he possesses the required experience. The Commission may, at its discretion, require the broker to provide evidence of possessing the required experience. It is possible for some brokers with exceptional equivalent qualifications other than brokerage experience, for example, several years of experience as a real estate attorney or new home sales representative or corporate owner, to obtain a full waiver of the qualifying experience requirements. Others may be able to obtain a partial waiver based on substantial non-brokerage direct experience in a real estate transactions or substantial brokerage experience that is more than 5 years old. Experience waiver must be specially requested in accordance with the guidelines available on request from the Commission. After designation as a broker in charge, a broker must complete the Commission's 12-hour broker in charge course within 120 days of designation, unless the 12-hour course has been taken within the previous 3 years. Failure to complete the course within 120 days will result in the BIC being removed as BIC. The broker must then take the course before he can again be designated as a BIC. Broker in charge duties. The broker in charge is that primary person the Commission will hold responsible for the supervision and management of an office. See paragraph I of Rule A110 for a list of the specific responsibilities of the broker in charge. Broker in charge eligibility. Once a newly designated broker in charge completes the 12-hour broker in charge course within 120 days of his or her designation, he becomes broker in charge eligible. This status allows the broker to be redesignated as a broker in charge at any time in the future after a period of not actively serving as a broker in charge without having to again satisfy the qualification requirements for initial designation, so long as the broker continuously maintains his or her BIC eligibility. To retain this broker in charge eligibility, paragraph K of Rule 110 requires that a BIC must renew their broker's license in a timely manner each license year and keep the license on active status. Complete each license year the 4-hour mandatory broker in charge update course, as well as any approved 4-hour CE elective. The BIC update course must be taken initially during the first full license year following designation as a broker in charge and each license period thereafter. The BICUP course satisfies the broker's 4-hour mandatory continuing education update course requirement. If a broker in charge or broker with BIC eligibility fails to take both the BICUP and one elective CE course by June 10th in any given year, when required, then the broker will be removed as broker in charge or lose broker in charge eligibility for the following July 1. Termination of broker in charge eligibility at designation. Rule 1 of A110 provides that a broker's BIC eligibility, and if currently designated as a BIC, his or her BIC designation shall be terminated upon the occurrence of any of the following events: license expiration, licensee fails to renew their license annually by June 30th, suspension, revocation, or surrender. License made inactive for any reason, including the failure to complete all CE required for BICs. Broker is found by the Commission to have not possessed the required qualifying experience at the time of either initial designation or redesignation as a BIC. Regaining lost broker in charge designations or eligibility. See Rule A110M. Once a broker BIC designation or eligibility has been terminated, the broker may regain that status only by being redesignated as a BIC. It is not possible to regain BIC eligibility without first being redesignated as a BIC. In brief, the broker must first have a license on active status. If the license has expired, it must first be reinstated. If the license is inactive due to a CE deficiency, CE is continuing education, then the license must first complete whatever CE is necessary to reactivate the license, and in either case must then submit a reactivation form to the Commission requesting that the license be placed back on active status. A broker who has lost his BIC designation or eligibility should not take either the 12-hour BIC course or the BICUP course prior to officially reactivating his license with the Commission. Once back on active status, the broker must possess the experience required for initial designation and must first complete the 12-hour BIC course prior to reactivating redesignation as a BIC, regardless of when the broker may have previously taken the 12-hour course. There are no exceptions to this requirement to retake the 12-hour course prior to redesignation. Notice to the Commission when the BIC status ends. A BIC must notify the Commission in writing within 10 days upon ceasing to serve as BIC of a particular office. Exceptions for certain Subchapter S corporations. Non-residents. Non-resident individuals and firms holding a North Carolina broker and firm license and engaging in brokerage activity in North Carolina are subject to the same requirements as North Carolina resident broker firms with regard to when they have a designated broker in charge. Thus, a non-resident company engaging in brokerage in North Carolina must have a broker in charge of the company who holds an active North Carolina broker license for purposes of its North Carolina business, although the office need not be physically located in North Carolina. Similarly, a non-resident North Carolina broker sole practitioner engaging in activity that triggers the broker in charge requirements for the resident North Carolina broker sole practitioner, see previous discussion of this subject, also must be designated as a broker in charge for North Carolina purposes, as without a BIC, a company has no office anywhere. Education exceptions for certain non-resident North Carolina brokers in charge. A non-resident North Carolina broker who has been designated as the broker in charge of an office not located in North Carolina, who has no office, primary residence, or mailing address in North Carolina, is not required to complete the 12-hour broker in charge course and is not required to complete the 4-hour mandatory broker in charge update course to perfect BIC status or maintain BIC eligibility, so long as the broker has no North Carolina addresses. Drafting legal documents. This rule prohibits licensees from drafting legal instruments, i.e. contracts, deeds, deeds of trust, etc., but does allow them to fill in the blanks on pre-printed sales or lease contract forms, which is not construed to be the unauthorized practice of law. Offers and sales contracts. This rule specifies that minimum terms must be contained in the pre-printed offer and sales contract form a licensee acting as an agent proposes for use by a party in a real estate transaction. Reporting criminal convictions, Rule A0113. Licensees are required to report to the Commission any criminal convictions for a felony or misdemeanor, any disciplinary actions taken against them by any other occupational licensing board, or any restriction, suspension, or revocation of a notarial commission within 60 days of the final judgment or order in the case. This reporting requirement is ongoing in nature. Note that driving while impaired is a misdemeanor and must be reported. Residential Property and Owners Association Disclosure Statement. State Law 47E of the General Statute requires that most residential property owners complete a disclosure form to give to prospective purchasers. This form seeks to elicit information about the condition of a property by asking various questions to which the owner may answer yes, no, or no representation. Failure to provide the buyer with this form will allow the buyer to cancel the contract by notifying the seller in writing within 3 calendar days of contract acceptance. Note, licensees in residential real estate transactions have a duty under GS 47E to inform their client of the client's rights and obligations under the statute. The Real Estate Commission also views the real estate license law as imposing on licensees working with sellers and buyers certain additional responsibilities to assure statutory compliance and serve their client's interest. Licensees are expected to assist sellers with completion of the form, but should not complete the form for a seller or advise a seller as to what representation or no representation to make. That being said, licensees should be certain to advise sellers that the licensee is obligated by law to disclose all material facts about or relating to the seller's property to prospective buyers, regardless of what representation the seller makes on the disclosure form. See Commission's North Carolina Real Estate Manual for full discussion of the disclosure law and the agent's duties. Sellers must also provide a mineral and oil gas mandatory disclosure statement to buyers prior to making an offer to purchase and contract. The form has been developed by the Real Estate Commission and to be available for download from the Commission's website at www.ncrec.gov. It is a separate form, and in addition to the Residential Property and Owners Association statement, a disclosure statement is not required for some transactions. For a complete list of exceptions, see GS 47. Broker responsibility for closing statement. Broker's responsibility for closing statements. The chief statute requires a broker, at the time a sales transaction is consummated, to deliver to the broker's client a detailed and accurate closing statement showing the receipts and disbursement of all monies relating to the transaction about which the broker knows or reasonably should know. The statute goes on to provide that if a closing statement is prepared by an attorney or lawful settlement agent, a broker may rely on the delivery of that statement, but the broker must review the statement for accuracy and notify all parties to the closing of any errors. Since virtually every residential transaction in North Carolina is closed by an attorney for lawful settlement agent, It is a standard practice for brokers to adopt the attorney's settlement statement to satisfy this license law requirement. Commission guidelines. The Commission recognized that the current HUD-1 settlement statement form used in residential closings is fairly complex and has some entries that a broker cannot reasonably be expected to verify. Consequently, the Commission has published in its North Carolina Real Estate Manual the following guidelines for brokers in residential closings where the HUD Form 1 is used. Quote, each broker involved in the transaction is expected to review the completed HUD-1 statement and to verify its accuracy and completion in accordance with the provisions of the sales contract. The broker is expected to confirm the accuracy of these entries about which he has direct knowledge. These would include items from the sales contract, like the sales price, earnest money, due diligence fee, if any, as well as items such as brokerage commission. With regard to entries on the HUD-1 representing amounts due to or from third parties, the broker may generally assume that the amounts for the charges and credits cited in the settlement statement are correct, unless there's some reason that would lead a reasonably prudent broker to believe that they are incorrect. However, the broker is expected to assure that all relevant charges and credits are appropriately charged or credited, i.e. entered in the proper column, to the borrower, buyer, and seller, and all calculations for prorated items, escrow reserves, interim interest, excise tax, and bottom line figures, i.e. total settlement charges for borrower, buyer, and seller, cash from the borrower, buyer, and cash to the seller, are correct. The closing statement should be immediately advised, the closing attorney should be immediately advised of any noted suspected errors or omissions. The broker must also be especially careful to take appropriate action in the event that he becomes aware of a misrepresentation of facts on the settlement statement that is potentially harmful to any party with an interest in the transaction. Note that the cited statute already specifically charges brokers with the duty to notify all parties of any errors noted. Discussion on the new TRID rules, that's TRID, discussion of the new TRID rules, closing disclosures, and settlement statements will be included when the manual is updated. This section addresses those aspects of handling trust funds that are taught in real estate broker pre-license course and rested on the real estate license examination for the entry-level brokers. I think I'm going to stop right there and talk about trust funds in the next video. Now, if this is doing you some good, I want you to reach down there and click on like. If this is doing you a lot of good, I want you to leave a comment and say, wow, this is doing me a lot of good. And if you'd like to share this with your classmates, click on share and put it on the class Facebook page. By the way, if there's not a class Facebook page, you might take it upon yourself to start one for your class and put it on the class Facebook page and encourage your classmates to join the class Facebook page. Just a suggestion. Now, handling trust funds is going to be on the next video. When you're through reading this, I want you to go to www.ncreexam.com and take the test. If you're not making an 80 on that test, you might want to read it again, listen to it again, and do some serious study. It costs $164 to fail the North Carolina real estate exam. You don't want to spend that money. See you next time.